Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, this is Stewart Andrew Alexander and welcome to the show. Now, my guest today is a mechanical engineer with multiple earned degrees, including Doctor of Business Administration. Now then, are you a product liability personal injury attorney who wants to avoid losing cases? If that's the case, then my guest today has some fascinating insights surrounding how to choose, craft, and conduct winning cases and avoid the losers. He's uniquely qualified in being able to explain the differences between the idealized textbook theories and the actual operation of real products, has made the transition to serving as an engineering consultant and expert witness specializing in product liability personal injury cases, including wrongful death, and is often approached to support unwinnable or underperforming cases that shouldn't have survived the intake screening or where a factually inaccurate lawsuit has been pursued. So, all product liability personal injury attorneys out there, let's not keep him waiting any longer. Founder of Lawsuit Consultant, Dr. Arthur Eckstat. Welcome to the show, Arthur. Are you there?
Hello, Stewart. Yes, I am. It's a pleasure to be here.
Let's just jump straight in then, Art. And could you just briefly describe in your own words, who is your perfect prospect? Who is it that you actually help?
I help product liability personal injury attorneys. I help them choose, craft, and conduct winning cases and avoid losing cases.
Okay, so I'm going to just expand a little bit on that in a few moments, but when you think about the people who you work with, the personal injury attorneys that you work with out there, can you just share with us, if you will, 2 to 3 common obstacles which prevent them from achieving their desired outcomes?
Well, their biggest obstacle is actually choosing to accept an unwinnable or underperforming case. Most personal injury cases are taken on a contingency fee basis, and choosing the wrong cases drains their resources with no return. Quite often, somebody will come to them, they've been injured, the cause of the injury appears obvious, the responsible party has deep pockets, they may even have some previous experience with the same or similar situations. There may even be a product recall out for what appears to be the same problem. First look, it looks like their estimated investments in the case appear to be reasonable, and the return on investment would be desirable. So just it looks like an ideal situation, but there are many of pitfalls that they need to be aware of.
Okay, so any other obstacles that you come across then, Art?
Well, the next most common obstacle is they fail to identify what's known as the actual and proximate causes of the client's injuries. An actual cause of the injury is the obvious something broke and they were hurt by it. But in order for that to be meaningful within a legal context, it must be something that was the product was defective and unreasonably dangerous, and it's something that the manufacturer was actually negligent in producing. And when it comes to, a lot of people don't know what the definition of a proximate cause of the injury is. The actual cause is the thing that, hey, this broke and this person was hurt as a result of it. But when you talk about the proximate cause of an injury, that means there's a product that was produced in a way that had foreseeable consequences if it didn't work because of the way it was manufactured. So the same apparent problem could be for different reasons. And in order to prevail in a case, an attorney needs to be able to identify not only the actual cause of the failure, but what was involved in creating that failure. Now, what did they do wrong and that it be shown that what was done wrong was done in a way that they should have foreseen the consequences. Does that help?
That helps quite a lot. I mean, I'm sure there are more obstacles that you've come across in all these years of that you've been doing this. Would you just share maybe just one more with us, please, Art?
Well, the other most common obstacle for the attorneys is determining the likelihood of proving the defendant's negligence. Just because they were negligent and it seems obvious that there was negligence, the ability to actually prove that they were negligent can be quite challenging. There are lots of ways that defendants can successfully hide their negligence.
Mm. So when you think about those three obstacles that you've just shared with us, and any other ones that you've come across while you're out there doing your work, could you just share with us, if you could, a case study, maybe one or two case studies where you've helped a client, where you've helped personal injury attorneys to overcome some one, two, three, combination of those obstacles, and what kind of results you were able to bring to the table. And obviously keeping client confidentiality in mind, but it would be great as a mini case study, just to show our listeners that you have had that experience and you have been able to create that transformation. So if you could, then just go ahead and just share something with us, please, then, Art.
Okay. As I say, over the years, there have been, frankly, the majority of cases that have come my way, I've had to turn away because of factors like we just discussed. Somebody has come in, they've told a good story, and even though it appears that something broke and that was the cause of the injury, unfortunately, sometimes it's just somebody's ineptitude or failure to be cautious that has resulted in their being hurt, and they just fail to take responsibility. There are cases where people will take an unwinnable case, the attorneys will unwittingly accept an unwinnable or underperforming case because they heard a good story, took the case thinking it was winnable, and then they, in further investigation and getting a hold of an expert like me, they find out that the story that they were told really violates the laws of physics. It couldn't happen that way. That happens all too often. Personally, I've had cases where somebody was hurt, and it really was a justifiable case. You want to get justice for their client, but what they find out is they take on a major corporation that has unfortunately learned over the years some of the many tricks to avoiding being held liable. There's multiple ways that defendants can hide the truth. They can, unfortunately, there are some experts out there who are, you've heard the term hired guns. They're posing expert witnesses that can include these hired guns who are unfortunately willing to testify to what they were retained to say. Sometimes the information you need is dependent on employees of a company, and testifying employees, frankly, can be afraid of losing their jobs and benefits if they're forthright. So, they'll suppress evidence. Obfuscation can include bearing relevant discovery responses, in reams or boxes of irrelevant discovery information that could actually overwhelm you. Unfortunately, even though it's illegal, sometimes damaging documentation is just removed from the records. And I've been involved in cases like that, and it's unfortunate, but it doesn't mean all is lost. And these are all things that an attorney needs to be aware of. But just because they may be there doesn't mean it's a lost cause. With the proper additional information, and that's frankly experts like myself can provide this kind of insight to say, hey, here's where you could run into trouble. Here's these red flags, and just because, you asked for a personal story. I had a major case, and like I say, I won't go into who it involved or even the industry because it could be relevant, where there was a person who was damaged for life, lost their job and other problems as a result of the damages that they were suffered. And the company that was responsible, I knew when I read all of the discovery information, there was missing information. That the data had been scrubbed. There was no doubt in my mind that was the case. But sometimes when they do that, if it's attorneys that are doing that on the other side, I'm not making an accusation here. I'm saying this is what I've come across, is that they're, just because they've removed what they think is the information that could be damaging to them, it doesn't mean they got all of it. I had a specific case, say with a major corporation, where I knew that there was missing information, but in going through all of the reams of data, I actually came across some abbreviations that hadn't been removed. I knew what they meant, and it was just as good as having it spelled out, because I was able to show what those abbreviations were, how they tied into the case, and as a result, there was in fact a settlement where there had never been one in a case like that before.
Mm. So, Art, the work you do seems to be really specific and really specialized work. I've never heard of anybody doing this kind of work. Are you? Is this a one-man show, so to speak, for lack of a better term?
At the moment, it is. There are lots of consultants and experts out there. We collectively understand that this type of thing goes on out there, and that we kind of collectively commiserate, if you will, over the fact that attorneys tend not to come to us as experts and consultants until it's often too late. And it's something that's gone on for a long, long time. The background on that is that personal injury attorneys, they work on a contingency fee basis. You've probably seen the ads. You pay nothing unless we win, that type of thing. Well, that's the case for most personal injury cases. The common cases, automobile accidents, collisions, slip and fall, that type of thing, I could almost call them formulaic. This happens, and everybody knows that there's going to be attorneys involved, there's going to be insurance company involved, and it's almost formulas over, hey, this type of case is worth this kind of money, and it's pretty much the everyday type of, I say, automobile collisions. When it comes to product liability attorneys, the product liability personal injury cases involve something that isn't in the norm. Something specifically broke. It wasn't a result of something like an automobile collision. Something broke that shouldn't have broken. Somebody suffered personal injury, and one has to demonstrate what the problems were, and in a way that it can be shown that the manufacturer was liable for the damages, that they should have foreseen the consequences of what they did. They manufactured what's known as a defective and unreasonable dangerous product that the manufacturer was negligent in producing.
Right. So, yeah. Sorry. Go on. Continue.
Go ahead and ask your question.
I mean, it's fascinating because most of the, like you said, you mentioned the advertisements that you see on the TV, and generally, like you said, car accidents, etc., people slipping on the water in a place of business, that kind of thing. But you never see any advertising for product failure or claiming on product failure. So I think you have a very unique niche, so to speak, that you've carved out there, and I think I think you're on a very good path there, Art, because it seems to be not a lot of people out there, if any at all, doing what you're doing. So I'm glad to be having this conversation with you and helping you to spread the word about it. So with that said, can we just move on and ask you, let's talk a little bit about some of the misconceptions that are out there. So when you think about the personal injury attorneys that you work with, the ones that you help, the ones that you know that you can help the most, what are some of the popular misconceptions they may have about choosing on crafting and conducting winning cases and even avoiding losing cases? What are some of those misconceptions out there, please, Art?
Well, what's unique, as you intimated, about the product liability personal injury attorneys is that it's not the everyday case. It's the fact that something unusual has broken and somebody was injured. And these cases, they have definitely characteristics such as they require a larger investment. They take a lot longer to settle. It's not formulaic in that each individual case is unique. And as you said, that is a more specified type of expert witness and consultant requirement. And
yeah, because when I think about General Motors, there was that the case of a few years ago, if I remember, because I was in the UK at the time, but I heard a case about General Motors, and they were being under pressure from the state attorney general to agree that, or to assume legal responsibility for injuries drivers suffered from vehicle defects. Is that something that you would specialize in, that kind of case?
That would also be included. That's like a situation where if you may be talking about the ignition switch problems that they had, they managed to hide that for, if I recall correctly, 13 years before it actually came to light. Because when it comes to major corporations with a mass-produced situation, they'll often do whatever they can to hide the facts of the case, because it can involve product recalls, which are very expensive. There can be all kinds of consequences, bad publicity, things like that they'll unfortunately try to hide. When it comes to the unique, rather than the major corporations with millions of products, if you get down to the smaller situations, because that is definitely an example of a major situation. If you get down to the more typical cases, somebody walks in to the attorney, they've been injured. The biggest myth is that an injured party with a good story makes for a good product liability lawsuit. And the reality is that every potential case must be examined with multiple considerations, any one of which could make the case a loser for both the attorney and their client. There are I've actually written a trilogy of articles that are 3 myths, and those articles are actually posted on my website. But that first case of myth number 1, if you will, is that an injured party with a good story makes for a good product liability lawsuit. They could have a situation where they can't identify an actual cause of the injury. They can't identify the proximate cause of the injury. These are all things where they need help with, because if they don't get help up front, then they can wind up either taking a case that they shouldn't have taken, or filing a case that is factually incorrect. The other problem, the next myth, if you will, is that they can always substantiate that obvious negligence. It's obviously somebody was hurt, obviously something broke, and as you say, it appears that it's so obvious that this happens, they wouldn't have a problem. But as I mentioned earlier, the defendants can have all kinds of ways of trying to hide that negligence. So one has to be able to actually demonstrate or prove that negligence in order to prevail in the case. And that kind of leads into the third myth, is that you don't need or can't afford an expert to assist you in deciding whether you're considering taking on a winning or losing product liability case. The biggest problem that the product liability personal injury attorneys have, they tend to be a smaller, select group. I say most of the attorneys are kind of doing the everyday personal injury, automotive collision, that type of thing. The people that tend to take on these product liability cases, they often don't realize how much investment that it takes to prevail in a case like this. They can drag on for a long time. It takes a lot of money. It takes a lot of time. It takes a lot of personnel. And the majority of the attorneys that do take on the product liability cases tend to be smaller firms. They're solo entrepreneurs or small firms that take these on, and a lot of times they just don't realize what a large investment it takes in both time, money, and personnel to hang on in order to actually prevail in a case like that.
So let's talk about some of the pitfalls that are out there then, Art. Can you just share one or two unknown pitfalls that the personal injury attorneys that you work with should be aware of?
Well, the first one would be kind of what I was just discussing. That's underestimating the resources, the time, the money, and the personnel that are required to litigate a product liability case to a successful conclusion. The second biggest pitfall, I would say, is if the failed hardware is manufactured outside of the USA or the UK by a foreign-owned company, it's often difficult to impossible to obtain the documentation needed to either prevail or negotiate a fair settlement. And I've been involved in cases like that as well. These are some of the reasons that the attorneys really need to talk to somebody up front. And that's really where my uniqueness comes in, if you will. I've been a consultant, expert witness for over 15 years. And during that time, as I mentioned earlier, the majority of cases have had to been turned away. And I found out that wasn't unique to me. It's pretty much the same thing I hear when I talk to other consultants and experts in the industry. And I say we've been complaining about it for a long time. The bar associations are aware of it. It's fairly common news within the industry. And one day, just a couple of years ago, I decided instead of complaining about this, why isn't somebody doing something about it? And since there wasn't anybody doing anything about it, I decided that I was going to be the one to do it. And that's how I actually created Lawsuit Consultant. It's getting out there in front of the cases before they're chosen, before they're filed, and convincing attorneys that it is to their best interest to engage a consultant early before they ever choose that case. And the reason that they don't do it, as I say, most of them are small firms. They're either solo entrepreneurs or they're small firm, and consultants and expert witnesses, they're an expense, and they're frankly an expensive expense. And so what the attorneys do, because they are trying to limit expenses, because it's all out of pocket, they don't get paid unless they win, they tend not to consult with the experts until they've already taken the case and they've filed their complaints, and then they get to where they think, okay, now I need to bring in the expert to just formally put down what they believe has already happened. And that's, unfortunately, is when they're making those phone calls or reaching out, and all too often it's too late. They've already taken a case they either shouldn't have taken, or they have filed, as you say, a factually inaccurate complaint, or they've, just through not knowing what the technical factors are, they have figuratively, literally messed up a case. I am not an attorney. I'm an engineer. I'm a technical expert. I understand why things break, how they break, and it's that expertise combined with the attorney's legal expertise that needs to be put together up front. And nobody's been doing that up to this point, and that's why I created Lawsuit Consultant, to get out in front of this and help these attorneys, choose the winning cases, avoid the losing cases, be able to see through a story that sounds great, but it couldn't have happened that way because that's just not the way things work.
Well, that's the kind of a good segue into my next question, Art. So what are some of the most common fears that these attorneys have about even attempting to choose or craft and conduct winning cases? What are some of the biggest fears out there?
Well, their biggest and most common fear is pursuing a losing or underperforming case. Remember, most personal injury cases are taken on a contingency fee basis. And that means that all the costs are out-of-pocket investments, and they're only recovered if and after the plaintiff attorney prevails. And as I say, the majority of product liability personal injury attorneys are solo practitioners or members of small firms. Product liability personal injury cases most often require greater investments of resources than the typical personal injury lawsuits, like the automobile collisions. When it comes to time, cases can take years to litigate. In fact, I would say the average case is settled in months at best and many years at worst. They can drag on for a long time. And a losing or underperforming case also represents lost opportunity to pursue more fruitful cases. When it comes to money, say product liability personal injury cases can require a large investment. There's significant legal costs, and especially if they drag on for years. And there's the support personnel. They have other people helping them, and it's tough to meet payroll when you don't have any money coming in. I've been involved in cases where, because it drug on longer than the attorney had anticipated, they actually had to wind up laying off some personnel until they actually prevailed. Because consultants and experts are expenses, they say attorneys tend not to bring them on board until they think that the consultants and experts are needed to support their case.
And it's such a shame because it's one of those things that I come across it in my own business that, they always say prevention is better than cure. However, human nature, we're more motivated to take action when we need the cure rather than prevention. And it appears that the same challenges that I come across on a daily basis also transfer over to your industry, where these attorneys are, hoping to save money on the front end and then realizing when it's almost too late that they actually have to do something, and then end up losing more money than they were hoping to save in the first place. Is that am I on the right line there, Art?
You are exactly right. It's a very good analogy. Preventive medicine helps with down the road costs, and I've actually been involved in a situation where the attorney, at the time they had contacted me, they had a good case. They didn't understand it. When I framed it in a way for them to realize what had really happened, why their client was injured, when they then went and pursued the case, it drug on, all kinds of, they say, obfuscations. And in the end, they ran out of money. They had to abandon the case, even though it was winnable. They just didn't have the resources to keep pursuing it, which was sad for both the injured party and themselves. It was lose-lose where it should have been win-win.
On the other hand, Art, if I'm thinking about the personal injury attorneys out there that are going to be listening to you speaking today, and I'm just going to play devil's advocate for a moment and put myself in their shoes. And maybe they're thinking, this Art guy is only just, he's spinning, he's drumming up fear. There isn't really an issue here. My question then, Art, is how common is it that a cure is actually needed more than the prevention itself?
The ability to choose a winning case is primary in their survival. They have, because they tend to be small firms, and I think that those who are in the industry know it's kind of their little secret that they wouldn't really want the public to be aware of. All too often, these solo entrepreneurs, these solo practitioners, they're sometimes like one case away from bankruptcy. These cases can be so big. There could be millions of dollars involved in the cases, but all the money has to be spent up front to prevail. And if they don't prevail, it costs just as much to lose a case as it costs to win a case. And they can basically put their business and more on the line pursuing a case that they think was a good one. And if it turns out it wasn't, they've lost it all. The time, the money, One of the other things, and actually would kind of segue into another common fear that they have, it's kind of behind the scenes, is that a person who takes on a losing case, they get a reputation for how well they do. If your reputation within the legal community for winning cases is anything less than stellar, everybody knows it. Your litigation opponents are much more likely to drag out proceedings, and they'll tend to make lower settlement offers. They're also more likely to go to trial knowing that the odds are in their favor. You want somebody in your corner that will help ensure that you're choosing, crafting, and conducting winning cases, and that's what I'm doing.
Well, it seems to me that somebody like yourself should be the very first stop. Whether it's a winning case or a losing case, they're going to win either way around. If it's a losing case and you bring that fact to the table, you're saving them a lot of time, money, and headaches. If it's a winning case, then obviously they stand a more chance of winning the case itself. So it's a win-win all around. So for any of you personal injury attorneys out there that are listening to this, I really think Art is the guy that you really need to be picking up the phone and calling before you take on any kind of cases at all. But hey, I'm just a layman. What do I know? Give Art a call himself. So Art, let's just move on to the next question. And whenever I ask this one, I always feel a little bit funny, a little bit strange, because it sounds so obvious, but I've got to ask it anyway. Why would the personal injury attorneys that you work with, why would they want to achieve the outcome of being able to conduct winning cases and avoid losing cases?
Well, product liability personal injury attorneys want to choose, craft, and conduct winning cases so that they can achieve justice for their wrongly injured clients. That really is the forefront of what the industry is all about, getting justice for injured clients who are wrongly harmed. And in doing so, they also reap the financial rewards as well as the enhanced standing among their peers, their prospective clients, and even their family and friends. And that's what truly winning these product liability cases is about. And of course, if they choose the losing case, they get just the opposite. They lose all that instead of gain all that.
Mm. Art, it's personal question time. Dare I ask you a personal question?
Absolutely.
Do you really enjoy what you do? Do you really love what you do?
Oh, absolutely. In fact, this whole idea of creating this whole concept of let's get out in front, it's all about getting justice for those who deserve it. One of the side benefits is, as you say, if you turn away the losing cases, why is a case a loser? One of them is, it's unfortunate, both here in the USA and I think the UK as well, there are a lot of people who just don't want to take responsibility for their own mistakes, their own carelessness. And if an attorney doesn't know any better and they take on that kind of case, and then when the facts come out, which they generally will, it turns out that, hey, this person's story just doesn't match reality. It's not the way it could have happened. It violates the laws of physics, all these kinds of things. We turn away the people who are trying to cheat the system. We actually provide justice for those who were wrongfully injured. Again, it's win-win, and I'm excited about it. In fact, if I could share with you my really big picture here. I mean, I got into this for the specific reasons that I talked about, but as I looked at this further and further, I said by getting in front of all these things, what we can really do is have a situation where we can actually improve the overall quality of products and have them available at a lower price. Because right now, virtually any product that you buy, part of the price of that product is product liability insurance. Everybody who produces a product knows they're going to get sued at some point for something. And if they can avoid those cases that never should have been brought, and the cases that are brought give them insight as to how to make their product better, I mean, the whole industry, if you'll forgive me, the whole world gets better because we actually wind up producing better products at a lower price and get justice for those who deserve it. That's my big dream. That's my big picture.
And I feel honoured to be a part of that, to play my small role in helping you to connect those dots, Art, because that is a amicable. It's a great mission. It's a great vision. It's something that I always say about entrepreneurs. It's down to us. It's down to the down to entrepreneurship. It's down to innovation. It's down to those people who grow a great big pair of kahunas and get up one day and say, hey, I'm going to follow my God-given gift, just like you did, to create something that's going to help society to become a better place. It's going to improve people's lives, whether it's their health, whether it's money, whether it's relationships, whatever the case may be. And I'm so glad that you took that moment to share your vision, because it is a very dry topic. But look at that. Now we know there's this almost humane vision behind all of this, behind the engineer, behind the attorneys, behind the personal injury lawyers, which don't, in the public eye, don't really have a great reputation in general. So I'm really happy that you just shared that. And I think it's also a great segue into my next question, because I just want to ask you just to share a little bit more about your backstory, because up until this point, you've shared a lot of great information, Art, that's going to help the personal injury attorneys out there. And I'm sure one or two of them are going to be asking, well, who is Art? Who is this Art Eckstat? What makes him tick? How did he get started? So with that said, if you could just share a short backstory and how it relates to the people who you help, the personal injury attorneys that you're helping today, so that they can just get to know you a little bit more, please. Go ahead.
For many years, I've been approached to support unwinnable or underperforming product liability personal injury cases that they shouldn't have survived the intake screening, or a factually inaccurate lawsuit has been pursued. I commiserated with other consultants and experts about the tendency of contingency fee attorneys to wait to contact us until it is too late to adequately serve them. And as I say, I decided a few years ago that someone should do something to address the situation, and that somebody was going to be me. So I created Lawsuit Consultant specifically to help product liability personal injury attorneys choose, craft, and conduct winning cases and avoid losing cases. I wrote a complimentary guidebook entitled 7 Keys to Winning More Cases for More Money that can be downloaded for free from my website. I also offer attorneys what I call a look-see case merit evaluation, where we review the apparent merits and or red flags involved in choosing whether or not to accept or continue to pursue, for that matter, a product liability personal injury case. And this standalone evaluation is performed without requiring a retainer or any agreements, things like that. It's an upfront service to say, hey, contact me, I'll help you right up front for just a fixed fee to determine, is this a case you should pursue, or is this a case that you should avoid? And you make the final decision, but I'm going to make you aware of the merits and the red flags involved so that you can make an informed decision, not just respond to what all too often is the emotional tie with an injured prospective client.
Hmm. As a radio talk show host, one of my jobs is to remain impartial, but I'm really struggling to do that with you, Art, because what you just shared there is just what we call a no-brainer. It's an absolute no-brainer for any of the people who you work with to just give it a try. They obviously have their nothing to lose and everything to gain. So, Art, we're coming. Unfortunately, the time's just flying so quick. We're coming towards the end of the show, and before we go, maybe there is something that I haven't asked you. Maybe you thought of something while you was talking. So, with that said, what would be your best piece of advice to the personal injury attorneys out there who are considering taking on those cases, taking on winning cases and not losing cases? What would you like to share with those people before we leave, Art?
My best piece of advice is to not take a case without adequate investigation of the factors that are involved. my look-see case merit evaluation can allow you to make the best use of your time and make or save you money. As you mentioned, there's a lot of time and money, resources that are involved. Spend them on the things that are going to help you, help your client, help society for that matter, and avoid the losers.
Perfect. So, Art, if there's somebody who wants to connect with you, someone who wants to get in touch with you, how and where would they find you?
Well, to learn more about choosing, winning product liability cases and avoid the losers, one can download my complimentary guidebook, 7 Keys to Winning More Cases for More Money, at my website, which is www.lawsuitsconsultant.com. That's lawsuits plural with an S in there. So it's www.lawsuitsconsultant.com. You can also find me on LinkedIn. If you type in Dr. Arthur Eckstat, last name Eckstat, you should come up with my LinkedIn site. And if you're familiar with LinkedIn, the way to get to the sites, it's linkedin.com/in/lawsuits consultant. If you need immediate help with a pending or ongoing case, you can call me directly. My phone number is area code 602-670-9651, and that's in the USA, so it's a country code of 1. Or you can just email me. My email is art@lawsuitsconsultant.com.
Well, Art, it's been a blast. I've really enjoyed this show. It's been really interesting. Thank you for spending the time to shine the spotlight on an issue within your industry that the personal injury attorneys out there now have a great option to choose before taking on any cases, winning or losing cases. They now have a great option out there. So thank you so much for coming along and taking the time out of your busy day to share this information with our listeners. Thank you.
Oh, thank you, Stewart. I appreciate the opportunity to share this dream I have.
Thank you so much. So, ladies and gentlemen, that's it. Another show with yours truly, Stewart Andrew Alexander. I will ensure that the contact details for Dr. Arthur Eckstat are on the website. You'll be able to listen to this show on iTunes, Spreaker, YouTube, Stitcher, and eventually on iHeartRadio also. So, until the next time, take care of yourselves and goodbye for now.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.